hopefully that'll work. Okay, just to jump in. My claim is that trademark law has closely evolved with corporate and antitrust law. In that sense, any claim or argument that trademark law has an internal traditional logic may be bound to fail. I instead argue that changes in the way firms operate and the laws governing firms show that business interests precede and inform trademark practices over time, and also explain trademark law's past and current shape. The law has moved from a narrow view of what firms can or should be allowed to do to a conception of the firm as able to do almost anything it wishes. This change in recent decades flows from the Chicago School's view of the firm, competition, and consumer welfare. Today, corporate and antitrust law defer to the firm as the arbiter of action in the marketplace, vaunt property rights as efficient, and rarely find management or firm actions to be a problem. This posture mirrors the current critique and state of trademark law. In simplest terms, trademark law also allows mark holders to do almost anything they wish with a mark and seems not to care about possible propertization of marks. I offer a reason for this outcome. The ideal of lowering search costs is not the key rationale behind modern trademark law, as those in what might be called the search cost school argue. It is in fact subservient to another mandate. As Judge Posner has stated, the general rationale of trademark law has come to be to promote, quote, competition and consumer welfare. But as built into statute and court decisions, those terms mean something quite different than the search cost schools would like, despite the fact that they rely on and cite those scholars. This deeper understanding of trademark history and policy reveals an important alternative normative vision, one founded in enabling firms to define and achieve their goals as part of the same theory of competition that dominates U.S. antitrust and corporate law. Thus, any thought of reform will have to overcome the powerful place the Chicago School holds in corporate competition and trademark law. In short, I offer that this article's diagnosis of trademark law provides insights about how trademark law works and its current foundation, which in turn provides a way to get out of the Chicago School trap and a path to different outcomes in trademark law. So, for the rest of the talk, I will try and quickly go through three eras in the development of corporate competition and trademark law. Roughly, the local competition era of limited firm charters, the national competition era, and the period since the rise of the Chicago School as, built out by Bork, Posner, and others that have become quite embedded in antitrust and corporate law. I hope to show that how intertwined the doctrines are, and that corporate and competition law underlie trademark law, and that basis will show that trademark law is designed to support management's use of a mark to pursue wealth maximization, rather than protect consumers or enhance competition in ways today's critics would like to see. In short, those who adhere to the Search Cost School of Trademarks might be surprised that trademark law is not directly about consumers, fosters expanded property rights in trademarks, yields the same firm-centered results over and over again, and that is precisely what the core theory enables and perhaps dictates. So, local competition. Firms were not always the unfettered, manager-driven maximizing entities that are common today. In the early era, firms and their companions' trademarks were seen as quite limited. Business practices and precocian conceptions of what firms could do informed trademark decisions. Fears of monopoly and the nature of business practices dictated and restricted the way firms operated. It's a little flashback to business associations. Remember, the ultra vires doctrine limited firms to business lines and activities as set out in corporate charters. Competition connoted only the independent rivalry of two or more persons, and it drew on a morality-based view concerned with fair dealing and passing off goods that defrauded buyers and sellers, not modern price competition. Economics of the era viewed markets as monopolistic or competitive, and there was very little conception of degrees of competition. This was a type of race for either limited supplies or to unload excess supplies amongst what was later called small dealers and worthy men. The binary view fits within the era's legal notion that there was either direct competition based on the facts and legal powers of a corporation, or there wasn't. These limits informed and drove trademark law of the era, which required directly competing goods and services to find infringement of a mark. Courts also looked to the nature of the disputing firms and corporate charters to assess whether competition was even possible. So imagine today, if you tried to open up Haagen-Dazs Milk Company, you know that Haagen-Dazs, the ice cream company, is going to come after you and you're going to lose. Yet, the case that those who are trademark junkies, which seem to have entered the room, know in Borden, the exact opposite result comes out. And in Borden, it was just unbelievably blatant, right? The ice cream company, being the newcomer, sets up a company with 50 shares. The guy who sets it up owns 47. He finds a guy named Charles Borden, gives him 1 share that apparently wasn't even paid for, so that he can say, hey, it's Borden, I get to use the name. Goes right after using Borden, and the Seventh Circuit completely acknowledges that the Borden name is a, quote, great value, identified almost universally with the business of milk and milk products and its predecessors. It also says that Borden constituted one of the principal assets of the appellee and widely known and identified with the goodwill and public favor enjoyed throughout the U.S. Court said, yeah, you still lose. Why? One of the key things here was whether they competed, and how they looked at that had to do with the charters. The court looked at the milk company's charter and denied relief because they were in different lines of business. There was no product crossover. The court said commercial ice cream is a separate product than all of the other ones that current company offered. But the company said, hey, we're allowed. They actually had to say we were allowed to go there. And the court said, yeah, but you didn't. So you lose. It's a very different world here. Charters also informed whether competition was even possible. In a case involving the mark Poland Spring, the hotel and water company objected to Poland Spring Railroad. And the court looked at them and said, wait, you're only chartered to do water and hotels. That company is chartered to do railroads. Go away, move along, nothing to see here. There's no way this can even happen. To be more specific, you could sometimes find charter analysis where the plaintiff came in saying, I've got a claim. And the defendant said, they're not even allowed to be in this space, and they lost. Supreme Court of Pennsylvania explained, the business the complainant is engaged in and seeks to appropriate the name for is ultra vires, has no standing in a court of equity for relief. So unlike the Borden plaintiff, this one couldn't bring the claim because it never had the power to engage in competition at all. The limited approach to firms' competition of marks worked while the economy was mainly local shops and low capital industry. Once the economy grew beyond that stage, business practices, the needs for management, and the law changed. The simple world of local business and direct competition was gone. With national competition, corporate competition and trademark law adjusted to accommodate the realities of companies making, advertising, and selling their goods and services on a national scale. Another case illustrates how far that come. Somewhat familiar to everyone, but just remember the Fleischmann Distilling case. This is where Black Label whiskey goes after a beer making using the name Black Label. The trial court followed Borden, saying, no real competition here, and thus, you lose. Ninth Circuit said, whoa, wait, and reversed. Because here, we now are in the world in the Lanham Act of 1960s that says, well, it's the impression that beer relates to whiskey. It's a low threshold or intolerance for confusion, and it connects to letting a mark holder have greater room to use its mark beyond its current market. The court made the point explicitly by reaching back to the Yale court case and said that we should be protecting a mark, quote, outside the field of its own exploitation, and that the use of a mark had to be, quote, so foreign to that of the senior user as to ensure against any identification of the two. In other words, the world of Borden's dead. Direct competition is no longer necessary. Corporations can prevent non-competing entities from using marks on non-competing goods. These changes supported a new world moving away from the progressive era's attention to potentially anti-competitive outcomes to one supporting firm expansion and where trademarks could be used as a lever to aid in that effort. Several changes led up to this moment. Restrictions on corporate power fell away in favor of allowing a firm to pursue almost any objective that was legal, right? Ultra vires dies. Corporate governance moved manager liability to a gross negligence standard under the business judgment rule. These and other changes allowed firms to pursue higher risk projects and accumulate capital like never before. In addition, advertising and branding practices helped firms move beyond local retailers and reach consumers directly. Trademark law moved to support the activity of new national firms over smaller old ones. New state and federal statutes allowed firms to register marks and protect them more easily and nationwide. The marketing industry heralded the advent of these new statutes as a, quote, golden age where, again, a quote, every commodity of large consumption will have its market leader firmly entrenched by advertising. The changes in business practices meant that competition law and policy faced entirely new questions. It was only in 1871, close to the date of the passage of the Sherman Act, that competition in economics was explicitly and systematically theorized. The birth of antitrust law saw debates about what competition was and whether policy should protect small dealers and worthy men, the Jeffersonian vision, or adhere to the view of individual liberty supported by strong property rights, freedom of contract, and classical economics. the debates were not resolved right away. Right? Different points in time, as I detailed in the paper, for all of the three major areas. But once they settled out, corporate competition and trademark law went into a current state, and I argue that the clear winner in this is the Chicago School of Law and Economics. What I think has been missed to date is how the core logic of the Chicago School has not only taken over corporate and antitrust law, but drives modern trademark law. So Burke and McDonald have started to look at some of this as well, and others, but they drew explicitly on Cosa's theory of the firm to explain how trademark law influences the boundaries of the firm. In that sense, the choices on whether to make or buy are aided by modern expanded trademark rights. But I'm going further, and I argue that Cosa's theory and later developments in the Chicago School regarding the ideal of consumer welfare play a much larger role in trademark law. The Chicago School's view of firm, deference to management, and competition underlie the core of modern trademark law. Bork's notion that antitrust law was always about competition and consumer welfare has been questioned, criticized, and frankly debunked. Most agree that this version of consumer welfare is not consumer welfare, but total welfare. But regardless of Bork's inaccuracies, his view has taken hold in antitrust law. Examining the Chicago School explanation of trademarks reveals the same logic underlies and fuels modern trademark law. Just as corporate law is designed to allow managers the greatest possible freedom in running a firm on the faith that this approach will maximize total wealth, so too for trademark law. Right? We all know trademarks are massively important assets, and trademark law is designed to support management's use of the mark to pursue wealth maximization. Now, both the Chicago School and critics of trademark law agree that search costs matter, and both invoke competition, but there is a divergence on what they mean, these terms. Several since Ralph Brown have argued if trademark law were truly limited to the information function, expansion might be less likely. But the problem is, in the full Chicago School approach, there's an additional claim about how this system is supposed to work. Consumer buying choices are supposed to feed price mechanisms and help prevent opportunistic behaviors by producers. This formulation is a remedy that's introduced into the market to produce efficiency. It is the neoclassical thesis by definition. The key problem is the Chicago School approach appears to ignore the way legal protection of trademark leads to branding strategies that change competitive arena, allows firms to compete on aspects other than price, and alters assumptions of a pure search cost approach. But the reality is Chicago School finds these outcomes to be quite efficient. Branding allows firms to both product differentiate and turn a mark into a thing with value and desired on its own, what Barton has called, I think, a hypermark, if I remember correctly. Rather than a system where information drives prices down, prices go up even for fungible commodities. These outcomes, potentially higher costs, rent seeking, product differentiation, merchandising, should trouble a view of trademarks as information devices that aid in reducing search costs, and one that holds that trademarks are not property. And yet Chicago School adherents easily dismiss these results. That's because the view of trademarks here is about much more than the search costs. Search costs are instrumental to the Chicago School's view of firms and competition. In other words, the true goal again is to grant mark holders the greatest range of options to maximize firm wealth through a mark. The deeper understanding of history of trademark law poses some crucial normative questions that trademark scholars and judges must address. It should no longer be sufficient to say judges and legislators deserve low grades for their failure to conform to the law, to the goal of minimizing search costs. Instead, any thoughts of reform will have to overcome the powerful place the Chicago School view of welfare holds in corporate competition and trademark law. Although that task is daunting, I believe by identifying the deep forces behind trademark law that we can offer a clearer target for future work. Abandoning the belief that trademark law's traditional conceptual workings exist or function in the way described, i.e. avoiding the Chicago School trap, opens the door to sort of reforms critics desire. Discussion of welfare costs and trademark policy can be crisper about harms to consumers and other views of welfare rather than serving total wealth maximization. In addition, the last few decades of empirical work in behavioral economics can be rallied to question the now identified core of trademark law. In other words, similar methods that have been used in both corporate and antitrust discussions. As a question of trademarks' function in the marketplace, one can reclaim the term information and recast trademarks as information devices that serve all in the marketplace rather than simply one side of it, thus perhaps removing it from debates about what welfare looks like and coming up with a functional question. In short, my hope is this understanding gives us a way out of the Chicago School trap and enhances efforts towards different normative outcomes that could lay the trouble with trademark to rest, with all due respect to Professor Carter. And I did go fast so that we could have more time to let the meetings commence.
So does, and I guess I want to sort of push you on a couple of points. One is, and I think you do this, I think, sort of better in the presentation than sort of in the original. There's a tendency, a natural tendency maybe in a lot of people's minds to conflate Chicago school and welfare economics, right? And they seem to me to be fundamentally different.
No, and your initial notes, my revised for this, should actually capture that. So
I think you do, and I think that's right. But I want to similarly try to pull apart the Chicago school and the search costs piece, right?
Okay.
Because I think search costs, I think there's certainly no inherent reason to think that search costs ought to serve a Chicago agenda. And indeed, right, as articulated, it's fundamentally a consumer interest, right? One that is not associated with expansive protection, but quite the contrary, right? Now, I think one could reasonably say search costs are not all there are to the world, right? And you should care about other things too. I'm on board with that. But I want to resist the notion that that a search cost rationale leads us to a conclusion that therefore trademark owners must get everything, right? Because in fact, in lots of circumstances, it seems to me it does the opposite. A search cost rationale ought to reject all of the trademark suits against keyword advertising, for instance, right? Because it's the ability to find a bunch of different things I'm looking for on a Google search result that actually reduces consumer search costs, not saying one and only one company can appear.
Right. Well, I think that's where, again, you and I agree. And maybe it's, my perception is that the problem is the search cost seems to be co-opted enough in the literature that's why I'm saying maybe change the game by calling it information where you and I agree, right? Like, it's the same issue, but for some reason, and I may be completely wrong here, it seems to me that once one starts to point to Landis and Posner and those things, that they see that as functioning in a different way. And so by just simply going, well, look, let's just talk about better information. Same concept, but we don't have to then follow that, slide into that. And that might be just a tactical ploy, or hopefully not just a ploy, but option. But that's where I think you and I tend to agree, right? Like, fundamentally, yes, that's how it should be, and yet it seems to always go oddly when the courts talk about it, off base. But you might have we can pick it up again later, but yes, I basically agree again, and want to be, if it's not crisp in the latest version, if you have a moment, let me know. All right, everyone's hungry, and it was just that awesome. No? Yeah, question? Please.
Well, actually, just one thing on the search cost point, because this is sticking in my. I mean, it seems like more attention is paid to the harms of search costs by people who pretend that it has had this deep effect on trademark law, when Landis and Posner are writing after a lot of the expansion has already happened. And I think the happiest thing that ever happened for critics of search costs is that Posner came up with that imagination cost, imagination expense in that, because look, this is long after dilution was a player on the scene, and and anyway, so I think people ascribe way too much power to the search cost theory than it's actually exerted on trademark law, given all that happened between the initial passage of the Lanham Act and the 1980s rewrite. But the question I want to ask about sort of your larger point is, you were at the materiality talk yesterday, right? And I'm sorry, I forgot the name of
Kugler.
Yeah, Matt Kugler's talk, right? And so let's take his paper at face value. I mean, that what he's identifying is real, in that people have a very strong normative sense that certain kinds of trademark uses that trademark critics say are okay and immaterial to consumers do in fact matter, and even if it doesn't in fact matter to consumers, well, gosh darn it, they feel that way, and certainly that's consistent with my experience of teaching this stuff. It's very hard to shake people's normative.
Yeah, and come over to a business school. It's a lot of fun to try and tell business people, what were you thinking?
Yeah, so independent of whether this is because of search cost theory or the Chicago school or whatever, I mean, this seems to be what people want.
Yes.
Yeah.
And I'm not sure what's the question.
Well, I mean, so what's the? Well, I mean, so where do we go with this, right? I mean.
This is why I go back to perhaps what we have to realize is that trademark law tends to really deeply work with what's going on in the marketplace, businesses, branding, all of that. And now I think there was a comment from the last session about How much of that is constructed by what's going on is a really great open question. But this is something that Mark and I have gone back and forth on, that the harder questions, I think, for IT in general, is this crispness about, well, what sort of welfare are we talking about? What does that look like? And there's been some really nice work on whether or not really what harm is versus not, right? If it's just this burden of imagination or not. And making a slow and steady claim, empirically, other methods, pure theory, logic, getting to those questions, and then running up against, but if consumers are actually in that space, I'm actually not sure what that means for trademark law, right? Because it could be that trademark law has to say, well, we ought to all behave this way. That doesn't seem like it's going to work. And so, the hard part is, we're not going to be able to peel back, in my opinion, the current practices of firm. But then the questions of, well, how far do you go with that, and when do you want to stop it, becomes very... Rebecca actually pushed me last night, and I think her point was, then maybe dive deeper is what she suggested, and probably a follow-up paper, in moments when, even within that, if I'm right, this is the dominant logic, what are the cases where they actually say, okay, that's a problem? I think they're rare, I think they're few, but maybe that's where you can drive a lever, saying, look, on your own terms, this is where we think this has gone too far, right? Yes?
I think I would take issue with the part of the last comment that traces the evolution of the Posner search costs account to after the expansion of trademark. It's true that there was a massive expansion of trademark protection between the passage of the Lanham Act and when Posner started espousing these theories, but there's also been a massive expansion since then, right? And an expansion that's more damaging in many ways, right? Like an expansion of the sponsorship language and other things that aren't dilution specific. The reason I didn't have any questions for you initially is that I think your paper is right on everything, and that it should just basically be on repeat in Congress or whatever. But I guess the only question that I have is, are you making a historically descriptive claim? Where does it transition from being a historically descriptive claim to a prescriptive claim?
It is essentially historically descriptive, and the prescription is that this hopefully then, when people just quickly have often said, so we should be thinking about competition, we should be thinking about these simple things because that's what trademark's supposed to be doing. I'm saying, well, be careful, because as far as I can tell, the way it's been put into statute and legislation and WIPO and everyone is absolutely the Chicago school view of how that works. So this is where I think, again, where Mark and I agree, is like that's unfortunate and might pervert what are the other welfare options, but then being very clear that this is the welfare option and what it looks like is the right next move about not just saying competition, but, well, what does that look like? And what are the ways it breaks out? So I don't have my normative claim is, right now, everyone working on what those normative outcomes and welfare, debates about welfare should be.
The very last thing I'll throw out is that people want a lot of things and enjoy a lot of things that are not good for them.
Yeah.
Right? In trademarks as elsewhere, right, they want social exclusion, as Barton has shown, right? They want copyright in ideas, right? If anyone who's ever practiced has had people come in and say, can I copyright this idea?
Sure.
Our system doesn't allow that because of X, Y, and Z, but it feels like you are entitled to it because you came up with it, right? And Chris Bergman has written about the psychological dynamics here. So, just that there's some sort of natural biological inclination to want something doesn't mean you should drive trademark policy.
True. And with that, I'm sure everyone has another inclination, which is called food. So, thank you all.